Today's topic is an important one, and increasingly it's important and a priority for our team at Organic Seed Alliance. The idea for this panel discussion today grew out of a project that we started in 2020 called the Seed Patent Watch Project. And we launched this project, which is still very much in its infancy, after years of discussion and research into the misuse and outright abuse of utility patents associated with seed, as well as other restrictive forms of intellectual property rights. As an organization, we regularly field questions from seed growers, farmer breeders, independent seed companies, seed savers on this topic. Questions that range from what IPR strategies are available to me if I want to commercially release a variety I'm working on, to understanding what, if any, IPR tool is associated with the seed that people are buying. Our hope is that the project can serve as a resource to increase seed IPR literacy, given its complexity. And under the umbrella of this project, we have already convened a number of conversations and events. We've developed some new IPR resources, which you'll hear about today. And we've written at length about these issues as well. We are also currently developing policy solutions and identifying other actions for changing the system. We are very much still in the learning and listening stage of this work, which is one of the reasons why I'm so eager for today's conversation. One of our speakers today, Paulina Jenney, is going to briefly touch on a few of the events that we've already hosted, again, under the umbrella of our Seed Patent Watch project. And I'll be popping in some articles and blog posts that we've published related to these topics as well throughout today's conversation. I'm also going to quickly pop into the chat OSA's organizational values, which are really pertinent to this project as well. They underpin our Seed Patent Watch project work. With that, I'm going to introduce our stellar lineup of panelists today. First, you'll be hearing from Will Gallagher, who's a law student at the University of Maryland Law School. He's also been an advocacy intern for Organic Seed Alliance for close to a year. You'll then hear from Paulina Borrego. She is a patent librarian at the Patent and Trademark Resource Center at the University of Massachusetts, Amherst. She's also affiliated with the Mass Aggie Seed Library. She has a great lightning talk about seed libraries, which I'll also pop into the chat box at some point. Paulina Jenney, who I just mentioned, is a graduate student as well. She's at the University of Montana's Environmental Studies program. And she too has been an advocacy intern with Organic Seed Alliance, working in this project area of the Seed Patent Watch project for close to a year. Lastly, we'll hear from Daniela Soleri, who is an ethnoecologist at the University of California in Santa Barbara. She has a research focus on local and Western scientific knowledge systems in small-scale agriculture and gardens for collaborative problem solving. We have a great presentation for you today, and we're going to work hard to ensure that we leave enough time at the end for questions and answer and conversation. So feel free to pop in some clarifying questions throughout the presentations in the chat box. I and others will do our best to answer them, and then we'll be uplifting other questions as appropriate during the Q&A component of today's session. So with that, I'm going to share my screen now and hand the microphone over to Will. Let's see here, give me 1 second here.
Thank you so much, Kiki. Hi, everyone, I'm Will. I'm an intern at Organic Seed Alliance, soon to be lawyer, hopefully, fingers crossed. And I just want to start out by saying a big thank you to Kiki and Kat and everyone at OSA for blessing me with this internship experience and for helping inspire my passions for agriculture. And as well as thank you to Paulina B, Paulina J, and Daniela for collaborating with us on this presentation. And thanks to you all for being here today. All right, so the relationship between seed and intellectual property rights is kind of a confusing and meandering road. So I'll do my best to distill the essential components into a couple of minutes here. And I'm mostly going to be talking about patents, although there are several other important types of IPR as well. So if we could advance like 2 slides forward, please. Thank you. So if I were to sum up the goal of patent law in one sentence, it would be it aims to incentivize research and development by offering 20 years of exclusive rights to market new varieties. And in return, detailed information about your new variety and the breeding process are released to the public in the form of the patent application and any supporting documents. So the story really begins in 1790 with the passage of the first Patent Act, and that covers any, quote, process, machine, or composition of matter, end quote. That language remains unchanged today and forms the backbone of the utility patent statute, which has come to dominate as the most powerful and lucrative form of IPR in the modern seed industry. But it was not until 1985, nearly 200 years after utility patents first came around, that the first utility patent was granted on a plant. And this is because Congress, courts, patent examiners, and pretty much everyone else agreed for a long time that products of nature were not utility patentable. And supporting this idea is the fact that Congress has crafted these two distinct laws, the Plant Patent Act and the Plant Variety Protection Act, that try to be sensitive to the nuanced concerns posed by ownership and control over seeds and genetic material. So the Plant Patent Act covers asexual varieties, and the Plant Variety Protection Act covers seeded varieties, and now asexual varieties as well, as of the 2018 Farm Bill. And while the PVPA isn't technically a patent because it's overseen by the USDA rather than the Patent Office, for most intents and purposes, it looks, sounds, and smells like a patent, although it's much easier to obtain. And the PPA and PVPA come with very important exceptions that limit the scope of control that the seed developer has over the variety. So with the PPA, coverage is limited to the actual plant itself, and infringement is only found when a part of that plant is taken and used without permission, and that can be difficult to prove. With PVPA seed, the buyer retains the right to save seeds for replanting and for personal use, which includes breeding, experimentation, and reselling limited quantities of seed. And these exceptions do not exist in the utility patent framework, which was not created to address seeds, but rather just inventions, technological advancements more generally. So in 1980, we had the infamous Supreme Court case Diamond v. Chakrabarty, which redefined the scope of utility patentable subject matter to include products of genetic engineering. And the court's reasoning in that case was basically that even though we have these other two forms of IPR that cater to plants, and even though the historic policy of the Patent Office was to reject applications on products of nature, the court said that a genetically engineered bacterium that was engineered to break down oil spills more efficiently was patentable because it had been sufficiently experimented on by humans, transforming it from a product of nature to a product of human invention. So the key distinction for patentability in the United States shifts from a question of whether or not it's a living thing to a question of whether it's the product of some inventive step undertaken by humans that creates something that would be unlikely or unable to exist in nature, such as Roundup Ready soybeans. And the effects of Chakrabarty on the seed industry have been enormous. I mean, it really marked the beginning of commercialized recombinant DNA technology, which has become an overwhelmingly abundant component of our food system today. And now utility patents can be granted on plants expressing a unique quality or trait, the seeds of those plants, the transgenes that have been added, the traits embodied in those transgenes, and also applications of plants to do whatever it purports to do, herbicide or insecticide resistance, or some beneficial quality or distinct phenotype. Those are all protectable by a utility patent. And as I said, there's no exceptions for seed saving or breeding. Like with the PVPA, you must obtain a license to use a seed that's protected by a utility patent. If we could go to the next slide, please. So I know this session is not meant to be like how to file a patent application 101. So I'm not going to bore you with all the details of patentability, but I just wanted to highlight the 4 major requirements because I think they can help shape our understanding of how seeds may or may not fit into this framework. So these are subject matter, novelty, non-obviousness, and enabling disclosure. We've already talked about subject matter, and besides that, the most significant hurdle for a seed developer is novelty. So to be considered novel, a patent examiner must not be able to find any information about that variety anywhere on the internet, in a farmer's field, or anywhere in between. It has to be completely new. As you might imagine, this can be like a Herculean task to try to search through the entire body of information that exists both on and off the internet to try to figure out if the variety is new or not. So if information about a variety is not published online or not included in a major seed catalog or a trade journal, then it may be overlooked and a patent application may be granted erroneously. And the dangers of appropriating seed via this mechanism is real, and I believe pretty substantial. Next slide, please. So patents really gain their full scope of power when they're combined with licensing agreements, which are legally enforceable contracts that accompany the sale of seeds. So contracts to grow patented seeds are filled with provisions that do more than prevent seed saving and reselling and breeding research. They basically transfer all of the burdens caused by ineffective seeds or contamination events directly to the farmer, regardless of who's at fault. And they allow the patent owner to look at farmers' records, and in many states, even go onto the farmer's land to test samples for infringement. And in the legal world, we call this a contract of adhesion, where you don't really have much of a say in negotiating the terms. You can either buy the seed or find another supplier. And even if you've never signed a contract to grow patented seeds, you could still theoretically be responsible for infringement if they show up on your field by accident, like wind dispersal or some other form of seed movement. And the vast majority of commercialized patented crops have a single genetic modification that gives them resistance to herbicide or pesticide that is usually also sold by the seed developer company. So it sort of creates a revolving door of profit. But efforts to improve nutrition and taste and yields and soil health or other positive traits are less profitable and thus scarce in commercialized agriculture. And of course, the patent system is very expensive and cumbersome to navigate, and it does not apply in many situations. But I think more importantly and more fundamentally, it just might not be what the breeder wants or envisions as the best way to steward and protect seed. And I think that's something that we need to be sensitive to. Next slide, please. So in addition to patents, we have trademarks, trade secrets, and open source seed initiative, Aussie Pledge. Trademarks can be used to protect brand names of varieties, and they exist independently of the patent laws. And I think Paulina J is going to talk more about that. So I'll move on to trade secrets, which are confidential information, such as a specific genotype or planting strategy that is both economically valuable and subject to efforts to maintain its secrecy. So for example, an inbred line used to create F1 hybrid could be protected as a trade secret, or other information about planting or breeding strategy. And protection for a trade secret is automatic, just like copyright. So you don't need to apply for trade secret protection. There's no trade secret office anywhere. It attaches as soon as the requirements are met. And the Aussie Pledge is a promise to free a seed and all of its progeny from the constraints of IPR. And it operates sort of like a bag tag contract. And I'll just conclude by saying, regardless of your position on or use of IPR strategies, I think it's important to just be aware of what's out there and how IPR are being used by different players in the industry in different ways, some positively and some to the detriment of smaller scale and organic farmers and breeders. And if you're interested in learning more about specific avenues for challenging potentially problematic utility patents, I've uploaded a lightning talk to this conference that discusses several different options going through the patent office for doing that. And that's it for me. So thank you.
Thank you so much, Will. That was really helpful. I'm going to pass the microphone over to Paulina Jenney.
No, Paulina Borrego.
Borrego, thank you. Good grief. Thank you. So many Paulinas in one session. Okay, take it away, Paulina.
So thank you, everybody. I come to this as a novice seed saver, so I'm completely new to this. and run the Mass Aggie Seed Library. But for this presentation specifically, I come to this as a Patent and Trademark Resource Center librarian. So next slide. So my goal today is to empower you to learn about the world of patents and some resources to help you do that. So as the established patenting authority, the United States Patent and Trademark Office has much information and resources to the public. So it can be overwhelming. So what I hope to do is to give you some resources and bring it down to the people level. So one of the best things is to look at all the resources that they have available to educate yourself. So I'm putting in the chat a link to some of the events, and they have events every single week. We're free, open to the public, virtual, to help you learn about patents. So next slide. A few years ago, there's the mothership, the United States Patent and Trademark Office in Alexandria, Virginia. But a few years ago, they broke up the United States into different regions, and these different regions have different programs and services that are available to everybody. And so that's a great place to find some information and to get some help. Next slide. And specifically, this is the best, one of the best resources for you. This is the Patent and Trademark Resource Center program. So the Patent and Trademark Resource Center program, and I'll put that link in the chat, is a program that began all the way back in 1871. I know, best kept secret ever. So these Patent and Trademark Resource Centers are located around the around the country, and they're a combination of public libraries, university libraries, state libraries, and a few special libraries, all staffed by librarians who help the regular people. So if you think of yourself as a regular person, you can make use of the Patent and Trademark Resource Center. Next slide. So these Patent and Trademark Resource Centers are open to anybody. And again, they're staffed by USPTO trained librarians. And these librarians are willing to help you in a lot of different things to help you understand the resources, the process, how you go about getting a patent, things like that. And this is just a picture of my little Patent and Trademark Center resource kiosk that I have in my library that's open to anybody. So these librarians are incredibly generous with their time. And on average, when someone comes to me wanting to learn about patents, how to search for patents, I think the first consultation, when I kind of teach them how to do searching, I usually spend at least 2 hours with them to give them like the lowdown of how it all works. Next slide. The one thing you should know is that these librarians are not lawyers, so they can't give you legal advice, and they cannot help you fill out the applications because the applications themselves are a legal contract, but they can help you understand how the whole system is set up and how to best go about getting resources that are available to you for free. Next slide. So one of the things that they are best at is helping you search for patents. So they can help you search for plant patents, utility patents, trademarks. We are all educated in how to use these different resources. And so that's an incredible opportunity for you to learn like what seed utility patents are out there, what trademarks are out there, things like that. Next slide. And just this last week, on February 1st, the USPTO launched a new search system. So that new search system is available to you on the internet to search from home. And so that would be a great resource to reach out to the PTRC, the Patent and Trademark Resource Center in your state, and have them teach you how to use that resource. So a lot of these people, as myself, are meeting with people virtually, so you don't have to go into the space. And so that's something that's a great resource to you. And so I would just end by saying that this is the system that we have. And I know some people want to work outside the system. Some people want to work inside the system. So as a librarian, I feel that information is power. And so I encourage you to reach out and educate yourself about the resources available. Thank you. I'll hand it over to Paulina J.
Thanks, Paulina. Take it away, Paulina Jenney.
Thanks, Kiki. Yeah, I am Paulina Jenney, and I am coming from the University of Montana in present-day Missoula, which are the traditional homelands of the Salish and Kalispel people. So as part of my work for my master's in environmental studies, which I'm currently doing for the past year, I have been working as an advocacy intern, primarily on OSA's Seed Patent Watch project, which Kiki already talked about a little bit. And really the Seed Patent Watch project, as she said, was launched as a way to answer questions that people have about intellectual property rights, as a way to raise awareness about the problem of utility patents on seed, and as a platform for research, discussion, and policy change. So next slide, Kiki. So part of that work really means understanding how organic seed growers perceive the impact of intellectual property rights on seed. So in the 2022 State of Organic Seed Report, which will be released in the coming weeks, researchers and seed producers were asked their opinion on some of the more dominant forms of IP in the seed system. So those surveys were sent out to 83 researchers from both universities and organizations across the country, to 416 seed producers from the NOP list of certified operations, and to 90 organic seed companies. So response rates for those were 61% for researchers and 25% for seed producers. So as you can see, while there's some discrepancy between researcher and grower opinion, overall both groups really agreed that utility patents are perceived as the most harmful form of IP, while the Aussie Pledge is perceived as the least harmful. Next slide, please. So these perspectives are further elaborated upon in more qualitative ways through conversations we've been having with seed growers. So over the past year, we've engaged in conversations on a variety of platforms. So last January, we hosted the listening session on intellectual property rights. And then later last year, we had a community conversation on intellectual property rights, race, and colonialism with Anjali Vats and Ernesto Hernandez Lopez. And both of those events were open to the public and widely advertised. And then during our seed production course, which ran for 6 months and was open to people who are dedicated to, but kind of just beginning their seed work, we had an entire module on IPR, during which we were able to ask students, like, what are some of the perceived benefits of IPR? What do you perceive to be some of the negative impacts? And then also what questions you might still have. And then as part of my master's program last spring, I conducted a qualitative research project, which involved purposively sampled conversations with seed growers, really on a range of scales. So I interviewed a backyard gardener, keepers of local varieties, university plant breeders, and owners of seed companies, both small and large, some of whom had engaged in intellectual property and some of whom had deliberately chosen not to. So even though we know that these conversations don't fully capture the range of perspectives that seed growers might have on intellectual property, we felt that these conversations were really a good starting point to understand some of the more common themes and questions that people who work with seeds tend to have. And of course, one of the overarching questions is, how does a person who wants to work with seed navigate the question of intellectual property in a way that's ethical and financially viable? And it's a really sticky question to try to answer. And so, of course, really, there's no silver bullet solution to IPR for every seed grower. So as Will has already talked about, the IP laws in this country have left us with a confusing array of strategies that can be easily flouted, that contradict each other, that cancel each other out, and none of which really fully honor the relationship we have with seeds. In addition, centuries of colonization have resulted in the loss of so many regionally adapted seeds, and also really resulted in the disruption of relationships that until 200 years ago really fostered like the free movement for seeds from one community to another. And of course, we know that the vast majority of intellectual property rights in the US are held by just 4 major seed companies, and that those companies often leverage their IP portfolios to fuel the consolidation and centralization of power in the seed industry. So next slide, Kiki. Thank you. Well, we, maybe would have liked to come out of these conversations being able to say like, yes, this is the answer, or this is the one approach that is better than the others. Of course, what we find and what seed growers know to be true is that seed growers come from a lot of different backgrounds, and they work with many different types of seeds, and they have different goals for the work they're doing, ranging from just maintaining a local variety to trying to make a living as a seed grower or a plant breeder. And so I think maybe it's okay that there's no one size fits all solution if what we're trying to do in this movement is to decentralize. And so what we're left with, really, rather than a solution, is trying to compile resources that explain the situation we're in, and that really just attempt to fully understand all these options that are available to seed growers and plant breeders. And we're trying to do that by really telling those stories as much as possible in the voices of people who are really working with seed. So I'm kind of picturing it like a compendium of voices, and we're calling it the IPR Toolkit for now, although if anybody has a better suggestion for that, we're all ears. And so the sections as we envision them will include some background on the ascendance of IPR in the seed system and the problem with utility patents, which Will has already covered. And then we'll also include some information about how to know if seed has associated IPR. So I think there's a question in the chat about this. And admittedly, it's really not easy. And that's one of the biggest things I've heard, is that there's not a lot of transparency about IPR when it's transferred along the seed system. But there's some information about, sometimes seed catalogs have that in their listings, and then also about how to search like the patent in the PVP database. And I wrote a blog post about that, which I can paste into the chat in a second. And then we'll also include some descriptions of other non-patent forms of protection, like trademarks, contracts, defensive publication, and pledges like the one used by Aussie seed growers, and now also the Indigenous Seed Keepers Network. So we really want to talk about those types of IPR like through the profiles of seed growers who have leveraged those strategies and can speak firsthand to how much they cost, the amount of time that goes into applying for and defending that protection, as well as like why they chose to pursue that approach, like what they were working with, or the types of seed they had, etc. So next slide, Kiki. Thank you. So I think incredibly important to this too is understanding that IP mechanisms have a history of appropriating Indigenous knowledge, which is really a form of cultural violence. And Indigenous knowledge holds that seeds are living relatives. And so while those cosmologies are not a monolith by any means, many tribes believe that seeds are not to be sold or commodified. So working with culturally relevant seeds in this context requires a tremendous amount of due diligence. So some of the information in this section might include the way that international treaties like the Nagoya Protocol, which notably has not yet been ratified by the US. I think we're the only country besides the Vatican who hasn't done so. But how treaties like that might provide guidance about equitable benefit sharing. And then it also might include some information about working with the varieties in the USDA GRIN system. So as a lot of us know, the GRIN system serves as a major source of germplasm in the so-called public domain. But not all of those varieties were collected with consent from the people who developed them. And in some cases, taking those varieties without understanding where they came from or how the people to whom that seed was culturally relevant intended them to be grown is its own form of IP theft. So further, it's important to note that for many of the Indigenous seed growers I've talked to, there is the additional concern on top of breeders appropriating varieties of patented GMO traits containing or contaminating their carefully maintained open pollinated crops. And so I think that concern is also a part of this conversation. Okay, so one theme that does seem nearly universal among the folks that I've talked to is the concept of like good relationships in the community. So many of the seed growers I talked to believe that by maintaining open and candid communication with other seed growers and with the companies, seed banks, and networks that exchange seeds, like that can, in many cases, be an adequate protection that can kind of eliminate the need for more formal IPR strategies. But relying on that sense of community requires a shared understanding of best practices. So some of the more universal best practices I heard recommended, in addition to like open, candid communication, is the idea of preserving seed histories and giving adequate credit to folks who have adapted a variety. And also providing fair compensation to seed growers so that folks can continue to provide quality seed. Next slide. So finally, while of course community best practices can help to mitigate some of the more onerous symptoms of IP overreach, we believe that the problem is at its heart rooted in bad policy decisions. So looking at solutions, we've heard from a number of folks about patents on finished varieties or genetic traits that are not new or novel or non-obvious. And so there might be an opportunity to legally challenge some of these patents. But as Will pointed out in his lightning talk, that process can be quite costly. So if there are any IP attorneys on the call looking for pro bono work, we'd love to hear from you. And Paulina B has also noted in some of our conversations that patent reviewers are overloaded and backlogged with applications. And so they're not able to give like full attention to each application. And so patent applications require that the inventor cite prior art, but we've seen patents that seem to deliberately skip this step. So potentially alleviating some of that backlog could be a way to encourage more consistent patent review. Another potential avenue for advocacy that I've heard recommended would be to call for better funding of public plant breeders so that they're not forced to fund their programs through contract agreements with private companies who might restrict the use of the seeds they develop. And then finally, at the end, we're hoping to include an appendix of sample contracts and MTAs and those types of things to really like democratize these materials as much as possible. So this is just an overview of the project so far, and it's really been a crowdsourced effort. It's important to us because this question is so complex and there's such a range of opinions on it, that the resource really reflect the diversity of voices in the organic seed community. So if you're interested in sharing your experience, or if you think there's a particular perspective that's missing, or if you have questions you'd like to see answered, feel free to reach out to me either via DM or during the Q&A, or you can send me an email at any time and I'd be happy to talk. So I think that's it. Thanks, Kiki.
Thank you, Paulina. That was incredibly enlightening. Daniela, I know you want to share your screen. So
yeah, I'm going to do that. Thank you.
I can catch up on the chats a little bit here. Thanks, everyone. And whenever you're ready, Daniela.
Yeah, it's coming. There, can everyone see that? Okay, great. Thank you for inviting me to this session. Those have been great presentations. I already learned a whole bunch that I didn't know before, so this is a great experience. So I'm going to build on what Paulina J just talked about a little bit, which is looking at indigenous, or what I call farmers varieties, and starting local conversations about IPRs around those kinds of varieties. And just to place this in context, one of the issues that has persisted since the beginning of the development of Western IPRs relevant to crops is that it has been a top-down process, and the farmers who have stewarded, developed, stewarded, put intellectual and labor effort into creating these varieties have never been included in those conversations. So I want to give an example of an attempt to do that. So I'm talking about farmers' varieties, and in maize, those are often divided into races, and within races, there are farmers' varieties. And so here's an example from the southern Mexican state of Oaxaca, and these are just a few of the 35 races of maize that are present there. And within each race, there might be tens of land races, for example. So a tremendous amount of diversity has been developed between the work of farmers and their communities and the environments in which they're farming. And especially interesting is to look over here. This is Oloton, and that is the maize from the Sierra Mije that was the subject of the session, the great session last Saturday on maize, Mexico, and biopiracy. And that is a perfect example of what we tried to address in the research that I'm going to talk about, and it's still very relevant today. So this was research with the Pueblo of Zuni through their Zuni Folk Varieties Project, which was both Zuni and non-Zuni people collaborating in that project, and that was in the early 1990s. And the reason that we undertook this work was to respond to what the community was seeing. They were seeing things like Zuni blue popcorn being sold in the grocery store, farmed by an Anglo farmer in Colorado, Hopi blue corn chips in the fast food store. And they were angry and bewildered that people could just be doing this. And, well, not so bewildered, because it's just a continuation of appropriation that's gone on forever. So we were responding to what the community was seeing and trying to facilitate a discussion about Zuni crops and intellectual property rights. And to do that, we constructed scenarios that would accurately illustrate examples of what is happening or could happen with Zuni seed. And we worked on these scenarios, or through these scenarios, I should say, with Zuni farmers, with the Zuni Tribal Council, and with the Zuni Cultural Resources Advisory Team of religious elders. And just in terms of the construction of the scenarios, they were built around key practical aspects of seed IPRs, which are nicely laid out by this great OSA chart. The first of those is, how can seed be used? And I sort of blew up that little 3-box column that lists seed saving, breeding or research, and marketing. How can seed be used? And then who benefits? Obviously the holder of the IPR certificate or whatever kind of regime it is. But we asked instead, what are Zuni values about how Zuni seed should be used, and who benefits by the use of Zuni seed? So what I'm going to do is just give you this scenario. I'm going to read through it so you can close your eyes. I know it's a lot of words. So you can close your eyes, or you can focus your eyes on this beautiful Zuni and Hopi sweet corn. But I'll just give you the scenario the way farmers, the Tribal Council, and the Cultural Advisory Team experienced it. So they were also given paper copies, and we read it out loud. Ed Jones, a scientist with Better Seeds International, a large seed company, visits Zuni in October to collect seeds of a traditional blue and white corn. His company is looking for corn varieties that are resistant to drought so that they can use them in breeding programs to develop commercial corn varieties that Better Seeds would then sell. Ed drives around the fields and stops to talk with 4 farmers while they are harvesting corn. The first farmer, Dan, gives Ed Jones seed only after he gets Ed to sign a contract stating that if Better Seeds International ever makes any money from the seeds he has given, that they will pay Dan a fair share. The second farmer, Ethel, sells 10 ears of white and 10 ears of blue corn for a total of $20 to Ed. The third farmer, Mary, takes Ed to the tribal council, and together they agree on a contract between the Zuni tribe and Better Seeds International that pays the individual farmer for the seeds, but also gives the tribe a share of any profits made by the company based on the use of Zuni seeds. And the final fourth farmer, Jerry, refuses to give Ed Jones any seed, saying that they are the gift of the creator and should not be given to non-Zunis. So that's the scenario that, that's one of four that people were presented with. So if you'd like, you can think through that scenario and you can write down which farmer you would go with, which response you think would be most appropriate. And you can imagine that it's maybe seed that your family and your community had taken care of and developed over a long period of time. So to just show how that scenario reflects that structure of asking about these practical questions, I've laid them out in this little table. So you can see that each of these farmers is creating implicit or explicit areas in which the seed can be used. And most of them are saying that the seed can be used as a means of production, in other words, for research and breeding, for multiplication, and also that the product can be used, the seeds themselves can be sold. And whether that is restricted or unrestricted means that that use is contingent on some sort of benefit sharing. And each of those farmers had different ideas about benefit sharing, either an individual with ongoing benefits from future profits, an individual with just a one-time payment, or the tribe and the individual, hopefully with ongoing profits, or no use at all. And in theory, the benefit is for all Zuni people. So these were responses we got from the farmers, the irrigation unit meeting where we were, and also the tribal council. And the first thing you notice is that the responses are kind of all over the place. And that is really not surprising. There are many, many people that we spoke with were very clear about the ideal of having their seeds only for Zuni and not commercially used and not exploited in any other way by non-Zunis. However, almost everyone said that we also have to deal with the reality that we are living with and we are experiencing. And so there are these different answers about just direct individual profits from, or potential profits from using the seeds, making the seeds available, to others meaning, responses meaning that not only the individual, but the tribe should also benefit in this. And then you can see there were a lot of farmers especially who just said, no, we don't believe in that. We don't think that that is right. And if we go to the comments made by both the tribal council and the Cultural Resources Advisory team didn't vote, they just made statements. So I pulled out a few that I thought were really interesting. So the tribal council, one of the members said it might not be fair for just one person to hold the contract with Ed Jones. There should be a one-time payment to the individual, but then long-term profits coming to the entire tribe. The Cultural Resources Advisors said that they do not support the idea or practice of what they call crossbreeding, that is mixing two varieties to make a new variety. This is inappropriate for Zuni farming and would result in loss of the distinct varieties that are important to the Zuni people. We know the special qualities of Zuni corn are desirable, but this kind of crossing is only done for making money, and the Zuni people never get any of that money. They believe that there should be recognition and compensation, not only for breeding using Zuni crop varieties that is occurring now, but also in the future, and interestingly, but also for what has already happened in the past. And finally, they said making a decision about the availability of Zuni seeds and farm products to outsiders is difficult because different outsiders have very different histories and intentions. And they often mention sharing seeds with other pueblos in the region, including the Hopi most often. The policy would need to depend on who the outsiders are, how they intend to use the farm products, and if they actually use them in the way that they claim. So again, it's not a clear, simple, monotone response. There is a lot of variation within communities, and there are a lot of considerations that people are taking into account and raising in terms of these IPR scenarios. So the Cultural Resources Advisory Team made one general sort of overall ideal statement that Zuni seeds should not be sold or given to outsiders for profit, resale, breeding, or trademarking because of their significance to the Zuni people. This statement applies to all long-term food crop varieties of the Zuni people, including corn, beans, squash, melon, gourds, chilies, and peaches. And they also stated that this was their ideal, but they wanted to be involved in developing responses that were appropriate to what was being experienced by the Zuni people today. And I forgot to mention when I first introduced this study that everything here is from an approved public published description of the research. And I am not representing the tribe, but this is all publicly available information from the research. So we found that these scenarios really offered a basis for the community and groups within it to discuss IPR issues relating to their crops. And it provides documentation for the values that the Zuni have regarding their cultural, some of the values Zuni have regarding the cultural heritage in their crops. And the participants in these scenario discussions really considered substantive questions about cultural heritage and about the opportunity and responsibility for individuals and groups and benefits from those crop varieties. So my takeaway, I think, to suggest to you is to recognize first that there's no reason not to include communities and farmers in this discussion instead of having it always governed from the top. And that means being prepared for how messy it is and how diverse there might be in terms the diversity of ideas and positions, but that requires work in terms of developing methods that can work through that diversity, work through those different perspectives on IPRs, even just within a community and between communities. And this was something that a problem that was brought up in discussion of Oloton, especially the conflicts within and between communities that this has created. So let me know if you have any questions about it. And I want to thank all of my colleagues and co-authors from the Zuni Sustainable Agriculture and Zuni Folk Varieties projects. Thank you.
Thank you, Daniela, for walking us through that really important case study. It's so helpful to see these concepts and strategies applied to a real life event and example. With that, let's open it up for questions and answers. We're happy for anyone to raise their hand. You can come off mute and ask your question. We'll also be uplifting any questions we see in the chat box. But again, just quickly, thank you so much to our panelists. Those presentations were absolutely wonderful. Does anybody have any questions? Any questions among our panelists as well, or questions you want to pose to the group here? We have 80 people with us, which is just fantastic. You know, we are curious if anyone on this call has experience with any of the tools or strategies that we discussed earlier on in the presentations. We'd love to hear about your experiences, challenges, concerns, ideas, and other needs as you see them. All right, I see a hand from William. Go ahead.
Hi. I coordinate a seed catalog in a public library. So what are the pitfalls in my position, my director wanted me to inquire about doing that?
The pitfalls in, can you say that again, William?
Yes. Are there any intellectual property right pitfalls in lending seeds for the public to use in their own gardens in general from a library?
Does anyone on our panel want to respond to that?
I could take that. I forget who it was. What was it? The Organic Seed Alliance or Rocky Mountain Seed Alliance? That I know on the Mass Aggie Seed Library, I put in a little disclaimer about patented seeds, that we don't knowingly accept or distribute patented seeds. So there is a little verbiage that you should put to protect yourself. And I can send that to you if you want. It's also on my guide, so I can put that in the chat.
Thank you, Paulina. Thank you for the question, William. Next, we have Layla.
Hi, hang on, let me start my video. Hi, I had a question for any of the panelists, but maybe Will would be best able to answer. I was wondering, in the language of a utility patent, you said that traits could be patented. How is a trait defined in that? Because I feel like that could be kind of, is it like genes? Is it, there's always like, how is the gene expressed in a certain environment? How do you like, is it a trait that could be like across different crop species, like drought tolerance or something? Like, how do you define that?
Yeah, it's a good question. And it's kind of whatever you want to claim in your patent application, whether it's a very narrow circumstance or a trait that might be observable across a lot of different situations. Both could potentially be patentable. I think there's a lot of variability in what different patent examiners might look for, depending on what kind of situation you have and what kind of plant you're developing. So I don't really have a straight answer for you. I don't think there's a strict definition of what a patentable trait is. But to be clear, yes, it's the gene and the trait that is coded for by that gene are both protectable in a similar way.
Layla, I can give you a, oh, go ahead. Who's gonna weigh in?
Well, I can just add, I posted a little earlier an example of a variety that it called Enola bean that received both PVP and utility patent protection, and part of that was based on seed coat color and leaf color, and that was, you know, using color charts and, you know, described quantitatively. And it turned out later, when genetic analyses, fingerprinting was done, that it was identical to a public variety from Mexico. And eventually, it took quite a while, but eventually that those protections were removed from it. But part of it is just how much funding do you have to investigate it? You know, at what depth can you investigate it? The person that held the patents hadn't done fingerprinting.
And I can provide an example, one of many that we've identified, Layla, in that there is a utility patent awarded for the drought tolerant trait in broccoli. So if you read the application, it is a broccoli plant that survives and produces well in between a specific temperature range, and exhibits, again, drought tolerance in that range. Now, we all know that we could select for that type of tolerance in our own backyards. And so it's an example, in our view, of a misuse and outright abuse of the utility patent system. Now, they claim it's novel in their methods and many, many pages of arguments in their patent application, but that's just one example regarding a trait. a naturally occurring trait that has been awarded a utility patent. Jocelyn, go ahead.
Hello. Thank you so much. It's been a wonderful education thus far from each of the panelists. And I hope it's appropriate to express my frustration. I find it really illogical that the utility patent has this basis in the plant world and then doesn't allow anyone to use derivatives, but the derivatives themselves are from nature herself. And so to claim on the genius of nature for profit, it's just, I'm assured that everyone understands where I'm coming from, but anyhow, just continue to fight the good fight on that. So my question was just if anyone had any practical guidance for the organic seed saver on any books regarding this very important topic. Thank you very much.
Thank you, Jocelyn. We share your frustration, we at Organic Seed Alliance. You know, it was never Congress's intent for the Patent Act to be applied to living organisms. And so this is a relatively new challenge we're facing as seed communities over the last few decades. And again, yet the frustration is real. And one policy solution is for Congress to make the Plant Variety Protection Act, which Will described earlier from 1970, which acts like a patent-like protection, but provides important exemptions in the way of allowing seed saving and additional breeding and research with those PVP protected varieties. Congress could reestablish that as the sole IP authority over sexually reproducing plants. It's an uphill battle, to be sure. And yet I think we need to keep calling for what we need and what we believe is right. Any more questions?
Kiki, I would just weigh in on the question about books that have been illuminating. And somebody already mentioned in the chat, First the Seed by Jack Kloppenberg, who I actually think is on this call. So hi, and thank you for your work. But that was a book that I read before starting grad school that I felt really laid out the ascendance of IP in the seed system in a clear way. Another one I wanted to mention is The Color of Creatorship by Anjali Vats, who participated in one of our conversations last year. And I think the way that she explains the impact of colonialism on our seeds, or on our like the construct of intellectual property, I suppose. I just thought that was really informative. So I would suggest that book as well.
Thanks, Paulina. And we do hope to publish the IPR Toolkit that Paulina Jenney so wonderfully described earlier in the session later this year, the summer or early fall. I will share the other book in the chat. Other questions? Other resources that our panelists might want to share with the group that you haven't already?
I will just say that as a seed library, I welcome different types of seed into my seed library because I believe that conflict is a way to get people aware of the situation and to get them outraged. So, because I think a lot of people just don't know.
I agree. I'm also going to pop into the chat box if you really want to get into the weeds on this issue, especially how it pertains to public plant breeders. There was a summit hosted by public plant breeders and others in the broader seed community about intellectual property rights. I see Bill Tracy's hand is up. I should just let you take it away on this, but I was going to pop the proceedings into the chat. Bill, go ahead. Come on off mute.
Yeah, that's all I was going to do is pop the link into the chat, but you're quicker than me, so that's all I had. So
Thanks, Bill.
I also would refer to the University of Vermont, I think, the law school book on A Guide to Defensive Publication, which is one of the strategies that people have been talking about as a way to like preempt the application of utility patents in PVPs. So we can put that in the chat too.
Yep, I will do that right now. Great suggestion.
The University of Vermont is a Patent and Trademark Resource Center, so you might want to reach out to that librarian there. I believe he's a librarian and a lawyer.
Thanks, Paulina. This publication coming out of Vermont led Organic Seed Alliance and others, Bill Tracy, who's on this call, other university researchers and seed stakeholders to explore what a new database to serve as plant prior art, as a plant prior art repository, what that would take. Would it be useful if we could get the Patent and Trademark Office to commit to visiting this database when reviewing applications pertaining to seed, plants, genetic traits? There are other databases out there and pieces of literature that they use for prior art that they reference. And yet in our conversations with Indigenous seed keepers and other seed stakeholders, we arrived at the conclusion that, at least at this time, creating a repository could have the unintended consequence of bringing too much attention to, say, culturally important varieties and actually leaving plant genetic resources at too much risk for utility patenting. And I don't know if anyone on this call wants to speak more to those conversations we had or that concept, but I welcome others to share as well. It really underscored something Paulina Jenney was saying just about the importance of relationship building and trust in these conversations, given its complexity and given that so many of us have the same goal of perhaps protecting and allowing to generate new genetic diversity. And yet it's really, like she said, there's no silver bullet solution to protecting seeds from utility patents. So what are the strategies moving forward?
It was a great session with Native Seed Search last week, discussing this. I see there's someone who says their title is Native Seeds. If anyone is here from that session or from Native Seed Search, it would be great to have you speak up about this and the process that you all just went through.
Yeah, Alexandra, thank you so much.
Great.
Okay. Hi, you spotted me. Really interesting conversation. So thank you for all the information. I think it's a really good session. What I was just thinking about is, I think for the public and for seed savers and for academics, it's really trying to distinguish between what is a theoretical and academic exercise, and then when you're in the dirt and you're actually working with seeds. So that is just a lot of what I was thinking about, is that we had to come up with a policy that was functional for us right now with the communities that we were representing, and with our organization and the stewardship and the seed bank that we have, being responsible but also accountable for the history of the organization and for the type of collections that they did 40 and 30 years ago. So, I think that that's just my comment, is also, being very thoughtful about what this looks like in practice, and what is realistic for on the ground farmers, small gardeners, farmers, seed savers, and just being realistic about how to protect IPR, but also increase diversity, because we're talking about extinction in some cases. And so that's where we have to work with all stakeholders, with communities, about what the actual threat is. But thank you so much to the panelists. This was really enlightening. I feel like I have to do a bunch of reading right now. So thank you.
Thank you, Alexandra. There's the session that Native Seed Search led that Daniela is pointing to, unfortunately was not recorded. However, there are other sessions that were recorded related to IP, including UPOB and the criminalization of seed. And then, as we mentioned before, a couple of different lightning talks. If other folks can think of other sessions that have been recorded related to this topic, please pop them into the chat box. Other questions? We have a few more minutes here. We'd love to hear from other folks on this call. Other questions, other experiences you've had with IP? Was there anything missing from the outline that we shared from the IPR toolkit? We'd really love to hear any and all feedback. Erica, go ahead.
I'll turn my video on. I was just going to say, as a I do tomato plant breeding, and it really is a challenge to go and try to figure out like what germplasm can I use, what can I use. It's really, really difficult, and I thank all of you guys for your work on this, because any way to make it easier over time for small people like me to just figure out what can I use, what can I use. I mean, I feel like I have studied this stuff a lot and feel somewhat savvy compared to your average person, but it's still really, really complicated. And then another thing I was just going to say is for people's entertainment, or actually not that, it's frustrating, but if you actually go and look at a lot of these utility patents, I mean, like some, Frank Morton pointed out, like a lot of the ones on lettuce, I've spent hours reading these things, and it's like, the description is like, the leaves are green. This is for the traits, utility patents on traits. It's like the leaves are green and they're this thick, and they're, that's literally what it's describing. It's like, how is that any different than the lettuce that's in my refrigerator or the lettuce that's in my field? And it really is, and there's thousands of patents like that. It is unbelievable. So, and I know a lot of you guys who worked on this knows that, but I just thought I would point that out to, it's really, there's a lot of them. And there's one on pleasant taste in melons. It's like, are you joking? So yeah, so it is a big problem and a big frustration. So thanks to all of you.
Thank you, Erica. I'm curious, do you find you're spending time trying to find IP background on some of the varieties you want to breed with, or do you just not have the time as a farmer, a seed producer and breeder to initiate those conversations with either seed companies or other plant breeders? Just curious what, if anything, what that process looks like for you.
Well, I always go first to check to see if there's a PVP on the GRIN database. Mm-hmm. And then I go to the patent office and look to see if it's patented by variety name. Also look at the catalogs. I mean, obviously where I'm getting the seed from really matters too. So, if I'm getting seeds from adaptive seeds, like I know that there's not, going to be, IP on that. So it's just also where I'm getting the seed from. But, it's like I'm really trying to breed tomatoes with disease resistance, and it's like trying to figure out, do these have I mean, that's the thing, is that it really is not clear about what is patented, what is not patented. I think that's the biggest thing. And my understanding from what I learned from Frank Morton is that really a lot of these patents aren't really considered valid until they're challenged. And so we don't really even know, right? Like, a lot of them probably would be thrown out by a court if anyone ever had the money to bring it to court. Like, but who's going to do that? Who has that kind of money and that, so, and there's just so many of them, but yeah.
I hear you. Thank you for the comment. There's a comment, a question in the comments. Paulina J, do you want to share that one? No, I'm losing it.
Sure. It says, one question I have is that Will described the Aussie pledge as a bag tag agreement. Is there any legal recourse to finding someone has patented or otherwise broken that agreement?
I'll let Jack speak to this if he's on the call and is willing to speak about it, because I'm not actually sure if it's legally enforceable.
Are you with us, Jack?
I am here, thank you.
Hi, go ahead.
I'm asking, greetings. Well done, people. This is a really interesting and useful conversation. Since you raised OSCE, let me speak a little bit to it. You know, we are in a sense IPR, but really what open source is all about is opposing IPR. What we are trying to do with our pledge is mandate sharing. And so I'm also interested in Paulina's chart there. I really look forward to seeing the attitudes towards various forms of IPR, of which OSCE is sort of one, a hybrid sort of thing. But if I'm not mistaken, it wasn't the least harmful, it was the most helpful. Am I not correct about that? So, which I think is very different from being least harmful, and I'm very glad to see that. If you're looking for seeds, as Erica is, that you can breed with, OSCE has 500 varieties of pledged cultivars that anyone can use and access and share, as long as you agree to share with others. And there are 147 lines of tomato there. So try it out, take a look, and on Friday there will be an entire session on OSCE, but not in the United States, but the OSCE open source is in some senses an international movement now, and you can hear from people from India, from Philippines, from Argentina, from Germany, who are using this as a tool in part to protect, to prevent appropriation, but also to mandate sharing. And the bag tag that is referred to is something that was pioneered by the companies. It is not IPR law, by the way, it is contract law. And if you begin to make these nuances and distinctions, open source is, to the extent that it's enforceable, it's contract law. It's not intellectual property law. It's not patent or PVP, which takes some getting used to, but is not. It's an agreement between ourselves, between people who are purchasing. So this is an add-on that the company's trying to put in place, you know, to back up and to threaten people, as a matter of fact, when you see on the seed packet, by opening this, you agree to these terms. That's the bag tag. And it is maybe enforceable. The companies aren't even sure of it themselves and find that it makes people mad at them, so they're not using it too much anymore. But it's on the seed packet itself. And it's just like the software. You know, by opening this CD with the software on it that nobody uses anymore, you agree to these terms. In a sense, that's what OSCE does with its pledge. And we say, by agreeing, by accepting these materials, you agree in one sentence, essentially, that you have some rights to use this in any way you want. You're free to use it. Open source is about freedom, not about restriction. But to be honest about it, we got to say, yeah, there's a restriction.
Got it.
Thanks,
Jack.
The restriction is that you give these same freedoms to anyone else.
Hey, Jack, thank you so much for those comments. I'm wondering if we can turn it back over to our panel to reflect on that a little and hear from anyone else in the audience.
We have time for a couple more questions. I'm wondering too, we walked through the IPR toolkit, but are there other resources that people would find helpful? Erica's mentioned not knowing what you can breed with, for example. Jack touched on that a little bit with the OSCE pledged varieties. Other resources that are coming to mind during this conversation that we or other partners could collaborate on to fill current gaps. I'd also love to hear what people are taking away from this session today. You can either share with all of us here or pop it into the chat box. What will you be taking back to your seed work, to the communities you work within? Thank you for sharing with us. Just a few more minutes. Go ahead, Layla.
Sorry to take up more question asking space, but I'm excited about this topic. I was gonna ask if OSA ever, I know that you all collaborate sometimes with European breeders and like breeding projects, but have you ever talked to European growers or breeders about their IPR experience? Because I know it's a very different way that it's set up over there, but it can feel like similarly restrictive to farmers. And when I was working with farmers in France, they were sort of organizing against a lot of the restrictive regulations on IPR through like the national and the European Common Catalog and stuff like that. And then just to comment on what I'll be taking away from this, I really appreciated Paulina J's like bringing in the GRIN database and just calling all of our attention to the fact that like those seeds were the way that they were collected. You know, they're in the USDA database now, and it feels like you can freely access them, but the way that they were collected was in many cases a process of theft or violence, and that is definitely something I'll be thinking about for a while. So thank you for that, and thank you everyone. That was super interesting.
Thank you for those comments. As part of our upcoming State of Organic Seed report, we asked organic seed producers where they're accessing germplasm from, and we looked at that data through a regional network lens. And the only, the standout similarity between all the regions is the reliance on the GRIN system to these seed growers. And so to me, in our advocacy work, it really underscores the potential and opportunity to take a harder look and do justice to that concern, Layla. So thanks for bringing that back up. Other comments or questions?
I would say too, in response to that, there was a session earlier about seed names and seed histories. And I thought that there were some really good points raised during that discussion about, you know, if you're, for example, if you're going to access a variety in the GRIN system, really like digging into the seed history is one way of just going beyond that notion of like, oh, this is free for all of us to use, and I'm going to take it, but really trying to figure out where that seed came from, and how the people who had maintained that variety intended it to be grown, I think is a part of the seed history. And just learning to incorporate those histories into future iterations of that variety could be a really good movement for us as a community.
Absolutely. There was also a great session called Black Seed Stories that I believe was recorded. Again, make sure to go back in and check some of these sessions out. Any other questions or comments as we prepare to say goodbye this afternoon? I'm so grateful for everybody showing up today with your curiosity and presence. Thank you so much to our panelists. You clearly put a lot of thought and heart into your contribution today. I'm so grateful for, again, this stellar lineup of folks. As we prepare to close our screens, again, I would love for anybody who's willing to share what you're taking away from this session in the chat box. And yeah, just thank you again for joining us today. Thank you to Rebecca and James, our tech crew. We could not do this without you. So thank you, thank you.